All right, welcome back. Welcome back, welcome back. I hope everyone's doing well today. Any questions? Anything in your mind? No? Okay, we'll start. This is our final topic in zoning. Starting next class, we'll move on to eminent domain, right? That's where the government actually takes your property. Zoning is a little bit different. Zoning is where the government enacts different types of restrictions on how you can use your property. But it also affects who can live in certain properties. So the polling question today is designed to start thinking about this topic. So here's your question. It says, under the police power, a city can exclude unwanted groups. True or false? And far more than what your answer is A or B, what I want you to discuss is why, or maybe why not, or maybe how. So if I'm thinking about this. All right. Who am I up to?
Me.
Who's me? Oh, Marcella. Okay. What do you think?
I said true.
Okay. Why is it true?
I think they can indirectly exclude unwanted groups.
Indirectly? Okay, tell me why indirectly.
Maybe they can't put zoning or the zoning ordinance that says we don't want poor people, but through different zoning strategies with like property value, you indirectly exclude poor people.
Okay. Let me ask you a follow-up. Can they do it directly?
No.
You say no. And who's next?
Me.
Oh, ooh, you almost...
I'm next.
Okay, so let me ask you the question again to Marcella. Can they directly exclude unwanted groups? Maybe I should frame the question more precise for next semester.
No.
What do you think? Why not?
Because that would infringe on constitutional rights of like equal protection of the law, and that can go into like being a suspect classification if you start to say like if you start specifying by certain people, then it can raise a suspect.
Did you guys do a case in Conlon called Cleburne versus Cleburne Living Center?
Yeah.
Remember that one? What was that one about, if you remember?
They were trying to exclude like some minority group from living in a certain.
Wasn't just minority group. Justin, remember that case?
No.
I'll come back to you. Yeah, it's fine.
It was about Housing Act, right? And
yeah.
they were trying to. Was this about the mother and the?
No, that's more.
There, that was one.
Okay, but I'll get to more in a minute. Costa?
Wasn't it like mentally disabled?
Yeah. So this came from Cleburne, Texas. So everything's always in Texas, right? I got to check this, but the number of SCOTUS cases from Texas, I think, is higher than average. It seems that way, at least. So Cleburne was a case where the city said, we will not grant a zoning permit for a group home for mentally disabled individuals, right? That wasn't an indirect exclusion. That was a straight up, right, exclusion. And in that case, the court actually held, as you probably recall, that the exclusionary policy was a violation of the 14th Amendment. This was not a suspect class at Samantha's point, but it was one of these weird cases where the court applies what's known as rational basis review in a very rigorous fashion. So that was an outlier, though, right? What if instead of, I don't know, mentally handicapped people, I'll go back to Justin, the city passed a law saying you can't have a halfway house for people who are coming out of prison and trying to reintegrate into society, right? Well, they said you have these felons who are trying to reintegrate society, and they can't live within 1,000 feet of a school, hospital, playground, church, nursery, the entire litany, right? Would that sort of statute be unconstitutional?
I don't think so.
Tell me why.
So, I mean, that's similar to like how we register sex offenders and they can't live
Yeah.
in certain areas, and whether or not it unfairly keeps them from living in certain areas.
Yeah.
Is still upheld.
But, so I'm going to just finish it up, Justin. Why would the police power then allow you to keep away sex offenders, for example, or convicted felons, or, you name the group?
General welfare.
Safety, yeah. So there are certainly cases where the government can exclude people under the police power for purposes of safety, right, to keep society safe. Now, whether they'll actually engage in acts of violence or not, who knows? That's not as important. But the courts aren't going to closely scrutinize safety. The Cleburne case, I think, was a little bit different, precisely because it involved harmless people who weren't going to pose any specific threat to the community. It was based on, the court said, an irrational fear of mentally handicapped individuals. Okay? But that's under safety, right? We often describe the police power as the ability of the state to regulate the health, safety, welfare, and the morals of the people. The topic for today boils down to that last head of the police power, which is morality. Now, was it you, Brooke, with the dormitories in Alabama, right? Yeah. It was Auburn. Oh God, I said the wrong school. That's a big thing. I actually said in Alabama, not at Alabama, so I was fair. But a number of you may have had this in your colleges. I went to Penn State. I think Brooke went to Auburn. Female sororities were not allowed to have standalone houses. Did any of you have those in your colleges? No?
Not allowed to what?
That a female sorority was not allowed to have a standalone house. That their home had to be within a dormitory in the college. Anyone have that? Yeah, what school was it?
Sam Houston State.
Sam Houston State? Yeah, I'm sure it's around Auburn, Penn State. Now, the reason why, and there are probably lots of reasons why, but the generally understood reason is it's considered immoral to have unmarried women living on their own. People are laughing. But these are fairly long-standing policies that have been around since before I even knew when they existed, right? Are these statutes unconstitutional? And then you have cases involving, for example, Moore v. City of Cleveland, which I think you guys did study, where the state tries to regulate the composition of families who can live together in a certain unit. And then you have our first case today, Terre versus Boris, which involves regulating unrelated people who can live together. So the general premise is that the state gets discretion, that the courts give deference when the state enacts zoning laws that can effectively exclude where people can or can't live, right? The only exception to this sort of deference is when the law touches on some sort of constitutional issue. And this is one of those cases where property bleeds into con law, which is why it should be separated classes, because you already did East Cleveland, and it shouldn't be done in property, but I can do it here as well. Okay? The first instance in which zoning laws runs into the Constitution, let me see what you guys put here, by the way. What are the results of the poll? Oops, results. Oh, pretty divided. Yeah, I think the answer here is true. I think they do. Yeah, I think the Cleburne case is probably the outlier. I think this answer is better here is true. But going back to the question I was posing a minute ago, the first constitutional issue that zoning intersects with is one we studied already, which is actually the due process clause, right? If a zoning law is too vague and you can't know what's expected of you, we say it's void for vagueness, and that zoning law can't be enforced. But generally, courts uphold zoning laws against vagueness challenges. A second constitutional restriction that we should discuss is the free speech clause of the First Amendment. We mentioned this towards the end of class last class. And there's a bunch of cases, they're mentioned in your book, you can read them, in which perhaps architectural design might have free speech values, in which adult dancing might have free speech values, in which an adult bookstore, right, might have free speech values. There are cases involving signs that they can't prohibit you from putting a political sign on your lawn or a political sign in your window, right? So we have all of these cases concerning free speech. The next topic I want to discuss is freedom of religion. Now, did Professor Alfini do any free exercise stuff with you? Religious Freedom Restoration Act? You get it now. This will be your crash course at the bar, right, in the First Amendment, so listen up. The First Amendment says that Congress should make no law respecting establishment of religion, which is the Establishment Clause, or prohibiting the free exercise of religion. Following the ratification of the 14th Amendment, the states, too, cannot violate the free exercise of religion. Why is this important? Because certain boring zoning decisions take on a constitutional dimension. I'll give you an example. There's a case, it's not in your book anymore, is it? Verner v. Flores. I think they took care of your book. I'm annoyed. Anyone from Boerne, Texas or nearby? Where Boerne, Texas is? I think it's near San Antonio, right?
Yeah, I know where it is, and I was in a wedding that was at the church.
Oh, you went to that church? Beautiful church, right?
Yes.
Very nice church. So this is the, oh God, it was the St. Peter's, right? St. Peter the Apostle? I think it's St. Peter's the Apostle. Just Google that. But I think it's St. Peter the Apostle Church. The city of San Antonio designated St. Peter's Church to be a historical site. It's beautiful. I mean, just look at it. It's stunning, right? The Archbishop Flores applied for a permit to the city to expand the church. He said, we have so many people praying here, we don't have enough space for them. We need to expand the church. In other words, they wanted basically a exception to the historical designation, which allowed them to expand the structure. Now, generally, if you ask the government for some sort of exception, and you don't meet the requirements, they deny it. And that's the end of the story, right? But the Archbishop made a different claim. He argued that it violated his religious freedom. That the denial of the building permit infringed on his ability to exercise because he couldn't fit all of his congregants within the church. Now, did he bring a lawsuit under the First Amendment's free exercise clause? He did not. I'll tell you why. Under the free exercise clause, we have a very deferential test. There are two cases I need to talk to you about. Sorry, this is lecturing, but you'll need to know this eventually for the bar otherwise. In the 1960s, there was a case called Sherbert versus Verner. S-H-E-R-B-E-R-T, Sherbert versus Verner. Very important case. And the case involved the Seventh-day Adventist, right? Seventh-day Adventists celebrate the Sabbath on the Saturday, not on Sunday. In that case, the Adventists applied for unemployment benefits, and the state said, well, we have a job for you, but it's going to be working on Saturday. And you have to take this job. And if you don't take this job, we're going to deny you unemployment benefits. And the court held that that's a violation of the free exercise clause. That making her choose between the unemployment benefits and working on a Saturday was a substantial burden on her free exercise of religion. And that was the rule for about 3 decades or so. Right? Fast forward to the 1990s, and the court hears another very big case called Employment Division versus Smith. Employment Division versus Smith. Here you had a person who lost his job because he did drugs. But it wasn't any kind of controlled substance. He was a Native American, a guy named Al Smith, who used peyote, which is this like hallucinogenic cactus type thing, right? He used it for religious ceremony as part of his faith. He was denied benefits because the state said you were fired for doing drugs, we're not giving you your benefits. Even though Sherbert versus Verner ruled for the worker, Smith came out in the other direction. I'm not going to give you the details. It's a long opinion. But the upshot is the court said, when you have a law like a prohibition on doing drugs, it applies to everyone. It's generally applicable. That's the key word. It generally applies to everyone. The court's not going to carve out exceptions. So if the state wants to deny everyone unemployment benefits for doing drugs, they can do that. Right? So the Smith decision basically applied what we might call a rational basis review for free exercise cases. Very deferential. The court will not create exceptions. Smith was very, very, very unpopular. And Congress responded to Smith by enacting a law called a RFRA. Okay? Some of this is in your book, some of it's not. RFRA, which stands for the Religious Freedom Restoration Act. My favorite acronyms, RFRA. And as its name suggests, RFRA sought to restore religious freedom as it existed before the peyote case, before Smith, right? In other words, Congress tried to not overrule, but reverse the Smith decision, the peyote case. So the law says now that the government can impose a substantial burden on your religious freedom. And if they do, you can sue them in federal court. Now we know you generally can't bring zoning cases in federal court, and you generally can't sue the state unless the state gives its permission. It's what's called the 11th Amendment. Do you do the 11th Amendment at all? Yes, no? On the 11th Amendment, you usually can't sue a state without its consent. All right? So what happened to Archbishop Flores, right? He sued saying that the denial of his permit to expand his church imposed a substantial burden on his religious liberty. And this case went to the Supreme Court. A very important case called Bernie versus Flores. What did the court do? Well, the bishop lost because the court found that RFRA was unconstitutional. RFRA was unconstitutional as applied to the states. Why? Lots of reasons, but the one that's relevant to you. The court says it's our job to decide what the Free Exercise Clause means, not Congress. We get to decide what's a violation of the Constitution and not Congress. And because Congress overstepped its bounds, the court held that RFRA was unconstitutional as applied to the states. So we don't have RFRA anymore as applied to the states. RFRA still applies to the federal government, right? So if the federal government burns your religion, you can sue under RFRA, but not the states. But that's not the end of the story. After Bernie was decided, Congress enacts a new statute, which this one you'll find in practice, called RLUIPA. My favorite acronyms. RLUIPA. Ready? The Religious Land Use and Institutionalized Persons Act. I can't spell any of those words. The Religious Land Use and Institutionalized Persons Act. Why is it called that? Congress tried to craft a more narrowly tailored statute to protect religious freedom in the context of land use. So if any local government accepts federal money, which is basically all of them do, or if a prison or a home for institutionalized persons, right? Prisons or some sort of group home accept federal money, they now have to protect and give special exceptions for religious freedom. That's it. So this is the law that's in effect today. So if the city of Houston denies a permit to build something to a church, the church can go to federal court and say that denial burdens their religious liberty. Even if it's not done with bad intentions or any sort of animosity towards faith. And courts routinely say, give them this permit. In the normal course, if the city denies you a permit, that's usually the end of the road. But if you have a claim for religious freedom, there's an additional lawsuit you can bring to try and get this. And this is litigated a lot. A lot of prisoners bring this. A lot of zoning boards have challenged under this. This is a fairly common litigation. If you do land use, you'll see RLUIPA. It comes up all the time. So there's a long story short of saying that even to this day, our federal law provides a special protection for land use that has a religious nature, right? that certain building permits are denied, the court applies extra scrutiny if it involves some sort of house of worship or another religious group. Okay. So that was a very, very brief overview. But I want to give it to you so you have it. The book used to have an entire chapter on RIFRA and RLUIPA. They cut it. Again, I don't know why, but they cut it. So we're sensing a common theme. Anyway, it's not my call. I complain. Maybe the 9th edition will be a little bit better. Probably not. It'll be gone. You don't care. I teach it every year, so it actually matters maybe. For you guys are gone, it makes no difference to you. All right, so any other questions on religious freedom? Anything? No? All right, so we've done free speech. We've done freedom of religion. We're just making our way through the First Amendment. The next one is what you would call freedom of association. And that brings us to the village of Terre versus Boris, which is a very important case from the 70s, but it's been somewhat diminished because of East Cleveland and city of East Cleveland. Gabe, I think you're next. You want to give me the facts, please, in village of Terre?
So essentially, in Terre, there was a restricted land use to one-family dwellings.
Good.
And there was contention between the owners of the house, the Dickmans,
Yeah.
and 3 of their tenants who were all college students.
Okay.
And so they ended up violating it. And
Right. So specifically, what was the restriction in effect, right? Who could not live together?
it was excluding lodging houses, boarding houses, fraternity houses, and multiple dwelling houses
Okay.
as well.
Good.
And on top of that, a number of persons not exceeding 2 living and cooking together as a single housekeeping unit if they weren't blood related.
Okay, very good. So the key of this ordinance was that it limited the number of non-related people can live together, right? There were exceptions for housekeepers and other servants, right? But it excluded people living together. Now, this case is what, 1972, 73, 74. So this is in the 70s in New York. And you have a case where you have 6 college students all move in together. How do I put this bluntly? This was an anti-hippie ordinance. It's true. There was a lot of laws designed to shut down hippie communes and groups of people living together in this era. There was even a case, which you probably didn't study, called Department of Agriculture versus Moreno. Did you do that case? Congress basically passed a law to deny hippies food stamps. They said if you have a lot of people living together in one house who are not related, there's no food stamp eligibility. And if you look at the history of the law, they're talking about communes. And I swear to you, if you go to the oral arguments, they're all talking about hippies the entire argument. It's actually, it's an anachronism, but it was at the time. Anthony, is your hand up?
Yes. What was the third thing that you said? You said RIFRA, RLUIPA, and freedom of...
Oh, you're taking me back. Okay, so with religious freedom, you have the free exercise clause, you have RIFRA and RLUIPA. Thank you for coming back now to this case. You have this restriction on unrelated people who are living together. Okay? And they challenged the constitutionality of this ordinance. Now, we already did Euclid, right? And Euclid held that the government has a lot of discretion when they want to zone property. You know, 1 family, 2 family, apartment, industrial, these different types of use zones. But this case was different. It wasn't regulating the size of the house or how many families could live there. It was regulating the number of people who can live there. Right? Sorry. Lauren. It's okay, Lauren. So walk me through the court's analysis here, Justice Douglas.
The second case that they talked about?
No, walk me through Belle Terre, the analysis, please.
So they talk about the Seattle case and how it was different because it was the a philanthropic home for children And they say that like that's completely different.
Does the court uphold the Terre Ordinance?
Yes, the Supreme Court does.
Okay, why?
Because they say that the regimes of boarding houses, fraternity houses, and the like present urban problems, more people occupy a given space, more cars rather continuously pass by, more cars are parked, and noise travels with crowd. So it says that the police car is not confined to the elimination of filth, stench, and unhealthy places, and it's ample to lay out zones where family values, youth values, and the blessings of quiet seclusion and clean air make the area a sanctuary for people.
Okay, very good, very good. Thank you. So the government here, the government here asserts that they need this ordinance to protect the neighborhood, right? And it's always traffic. That if they have this ordinance, it will reduce traffic. Daniel, how does this ordinance reduce traffic?
I mean, if you had 6 people living in every house, it'd be just physically more traffic.
Lots of cars, right?
You'd assume I mean, they might have a car person, maybe not, but it'd be more than like 1.
So what if you have like the Brady Bunch, right? 8 people living together in one home, related.
You'd have a really big family car, probably. So it's one car.
No, but Marsha's a car, Peter's a car. You know, they all have cars, right?
I mean, if they did, then yeah, that'd be a lot of traffic, but that's...
So if the government was worried about cars, Michelle, couldn't they do something else? Like, how, if they were really worried about traffic, what else could they possibly do to restrict traffic?
I guess they could limit how many like cars per household.
Yeah. Limit the number of parking spots, right? Say each house gets 2 parking permits, 3 parking permits, whatever it happens to be. If you have a family of 20 and every person has a car, they'd be allowed to do this. But if you have 6 college students who take the bus everywhere, right? These kids may have one VW bug among them, right? But you know, if they have bus rides, do they actually contribute to traffic? But Anne, did it matter whether in fact the justification given by the city or the village was persuasive?
No.
Why did it not matter?
They said the police power wasn't confined to the elimination of filth, stench, and unhealthy places.
They were talking about hippies, by the way. I mean, if you know the context, this opinion makes a lot more sense. If you read the Moreno case, it makes a lot more sense. But yeah.
Good enough to say that they want the blessings of quiet seclusion.
But, and so just let me ask the question a little differently. Does the court scrutinize the justification given by the city, by the village?
No.
No. Sidge, what do you think?
No, I think they just kind of said it's rational that
Bingo.
someone wouldn't want traffic in
Yeah.
wherever they're living.
Yeah, so generally, when you have these land use decisions, the court affords what's called a rational basis review, right? And even though in the English language, rational basis means a reason that makes sense, in the language of the Constitution, rational basis means whatever, right? It could be the reason. Maybe it is, maybe it's not. We don't really care. One second, I promise. So when you apply the sort of deferential standard review, the actual facts are relevant. And Justice Douglas just turns it up to a 10 when we talk about the filth and the this and that and the seclusion, right? He's basically saying if the city wants to keep these hippies out, they can do it. And it's not for the federal judiciary to intervene to block their living together. Yeah.
So could they have like had an ordinance, sort of like how we talked about I guess a few classes ago, where they have the ordinance where your house has to be so far from the street or whatnot? Couldn't they have had an ordinance that says that if you have so many people in your house, you have to have like a driveway or something?
Garage.
Yeah.
Exactly. Yeah, this was my question to Michelle a minute ago, right? There are lots of more narrowly tailored statutes that the government could have drawn up, right? Mm-hmm. They could have done a lot more narrowly tailored things. If their concern was about noise, have a bigger front yard. If their concern was about traffic, have more garages, right? All of those things would have accomplished the same goal in a more narrowly tailored fashion without telling people whom they could live with. But when you have this sort of rational basis review, none of that matters at all. It's irrelevant because the courts are not going to second guess the decisions of the elected branches. The court says the concept of the public welfare is broad and inclusive. Pay attention, the court cites a case called Berman versus Parker. Berman versus Parker. We'll do that case. It's cited in our reading for next class, which is Kelo v. New London, the eminent domain case. Berman was a case from the District of Columbia in the 1950s. And the federal government wanted to basically use eminent domain to seize an entire block and redevelop it. So it's a redevelopment, right? And they said, well, we find that some properties here are blighted, meaning they're in bad condition. Other properties are not blighted, but we need to take the entire block. We need to take all the property in the block to redevelop it. We can't have one house here, one house there. And in Berman, the court upholds that as a public use, that redeveloping a community is a public use. And they can take the property for that reason. We'll discuss public use much more next week. But Berman v. Parker and Terre was both authored by Justice Douglas. And he had very little concern for property rights. It was just whatever. The majority can keep these filthy people out. These, what's it called, parasites from Euclid? Yeah, keep out the parasites. Okay. All right, so any other questions on the majority, the Douglas majority? Yes?
What did you say it doesn't really matter that it's a rational basis to do that?
The government justification doesn't really matter what it is, right? Whether it's true or not, whether it turns out to be effective, it makes no difference. So long as that could be a justification for their action under rational basis review, that's all the court needs to know. Thank you. Other questions on the majority? All right, Jenica, walk me through the Justice Marshall dissent. It was a solo dissent. He couldn't even get Brennan with him. You know, it was a rough go this time.
He does not like this.
No, he does not.
Well, so he says basically the main thing that I took away was that he said it's a violation, or it cuts into individuals' rights of privacy and their right to choose who they want to live with.
Mm-hmm.
And so basically, he said by this, they're limiting people who maybe can't afford to live in a home by themselves or don't have that opportunity, so they're not allowing certain people to live in these communities because they're not related.
Right. Yeah.
And so he harps on that.
Harps. Focuses.
Yeah.
Go on.
So anyway, so he says it's basically a lifestyle, and that it shouldn't, that it's an invasion of their First Amendment rights if we come in and say, oh, well, the ordinance is still, the zoning ordinance is still allowed, and it's pretty much going to be viewed under a rational basis instead of looking at it under, I think, kind of strict scrutiny.
Yeah, very good. Very good. Thank you, Jenica. So this is a very 1970s opinion, right? This was decided a year or two after Roe v. Wade, amidst the sexual revolution and the privacy revolution. And Justice Marshall grounds this right in a right of privacy, perhaps the right of freedom of association under the First Amendment. There is no association clause in the First Amendment. That doesn't exist. But the court treats the First Amendment as protecting a right of free association. You can choose who you associate with. And Justice Marshall makes the point that you can have more narrowly tailored ways to address concerns about population density. You can have nuisance. You can treat noise as a nuisance. You can restrict parking. You can have rent control. But this is an over-inclusive statute. You can't restrict a person's choice of lifestyle. Okay? So any questions on... Yeah, Mike?
If this was challenged today, would Marshall's dissent pretty much be the majority, more than likely?
Today? No. No. If he couldn't get a majority in the 70s, when the court was very different, I don't think he gets many votes today. But it's largely irrelevant because about 4 or 5 years later, you have, 3 years later, you have Moore v. City of Cleveland. And this restricted Terre, and it did so in an important fashion. Terre only regulated unrelated people can live together. more restricted related people. And they defined nuclear families, mom and dad and kids, right? And they prevented the grandma from living with her son and the two grandsons who are not brothers. And the court said that this intrudes on a right of familial choice in the 14th Amendment, wherever that comes from. This is what we often call substantive due process, where courts recognize rights in the due process clause of the 14th Amendment. And here the court says that a right of family unity and the sanctity of the family is one that's deeply rooted in this nation's history and traditions. You'll remember this from the Washington v. Glucksberg case, that the court's not just making crap up, that this is a deeply rooted right. So they say. All right, so any questions on Belle Terre or Morvey v. Cleveland? All right. There's a discussion in your book about NIMBY, right? This is the concept not in my backyard. And it's a very common facet of property law where zoning decisions are made to keep out certain people. Okay? Often, people just don't want certain things to change their neighborhood. People like where they are, they want to keep things the same. And zoning laws are a means of accomplishing that. So the book gives 10 different acronyms, which I find quite funny, to describe this. So one is Lulu. No, go away. Spam. Sorry. So one is Lulu, which is locally undesirable land use. Banana, build absolutely nothing anywhere near anyone. Gumby, gotta use many backyards. Lasby, look at several backyards. Niabi, not in anyone's backyard. Nimble, not in my bottom line. Nim2, not in my term of office. Nerby, never in rich people's backyards. Nibi, not in your backyard. Nope, nowhere on planet Earth. Or Yimby, yes, in many backyards. So all these sort of concepts pervade zoning law of ways you keep stuff out. And generally the courts defer when this is done. Our next case is an outlier, is an exception. And it's probably unlike any case you've ever read in property, and maybe even common law for that matter. Every year I say I shouldn't assign, and they say, no, let me assign. I think there's valuable stuff in there. But it's very long, I know. But I think it's worth studying. Now, I'll give you the upshot in advance. This is not a majority rule. No court anywhere has tried to replicate this decision. But it still teaches certain aspects of property law that I think are valuable to learn. All right, so any questions? All right, Marcos, you want to give me the facts in Burlington County versus Mount Laurel?
Yeah, there were a lot of facts, but I'll just try to keep it straight to the point.
Well, you start me off, and we'll see where we go there.
Okay, so in this case, there were a minority group, mainly Black and Hispanic, but they weren't the only people in the category.
Yeah.
Mount Laurel was a flat, sprawling township in Burlington County, and then the populace generally lived in individual houses scattered along country roads.
Mm-hmm.
There were several pockets of poverty with deteriorating or dilapidated housing. Residential development and some commerce began in that area. The population kept doubling throughout time, or kept increasing throughout time as industry increased. 65% of the township was still vacant or in agricultural use. The growth of the township has been spurred by the construction or improvement of main highways through or near it. So they were developing highways in the township, which that was what increased the population. And then it talks about how it was separated into R1, R1B, R2, and R3.
What was the general grievance, Marcos, of these groups? What were they complaining about?
Yeah, they were complaining that the people that were the minority group were complaining that they were forced to live in areas that weren't well conditioned because they weren't able to afford for the more expensive area of the.
Good. So very good. So this case, again, it's very unique. You have a number of different groups, the NAACP and other groups, who argue that the zoning approach of this community, Mount Laurel, violates the state constitution. This is not brought under the federal constitution. It was a case brought under the state constitution. And they actually asserted that the city had an obligation to zone in such a way to make it practically realistic for people of different backgrounds to live in different areas. All right? So Andrew, can you please walk me through, at a high level, I don't know all the details, but at a high level, why was it so hard for people living in Mount Laurel to live in areas unless they had some money?
Well, the majority of the land was zoned for high-income housing, and the rest was zoned.
Now, did it say you have to have a minimum income to live in this neighborhood? Is that how the law was drafted?
The zoning made the property they were zoned so that way the property would be more expensive.
Good.
And then the rest of it was strictly like industrial, even though the majority of the land zoned for industrial use wasn't really used. It was still like wooded.
Okay, very good. Yeah, very good. So it's not the case that the city simply said to live here you have to have a minimum income of X dollars, but instead they have zoning, which requires space. That if you want to live in R1, which is the top tier zone, you have to have X number of square feet, right? And if you want to live in R2, you have to have this number of square feet. The laws also made it very difficult to have any sort of apartment dwellings. One of the more bizarre aspects of this entire law effectively limited the number of children who could live in this area. Miranda, what was that law?
You couldn't have a certain number of, only have a certain number of children who lived in an apartment with two bedrooms.
Yeah.
I guess they said it was to keep educational costs, like school district costs low.
Yeah, and Miranda, what happens if too many kids were living in a given apartment?
Well, then they're all going to be going to the one public school, and then that's going to.
But what was the cost imposed on the developer?
Oh, well, the developer themselves.
Yeah.
Not anything.
You know what I'm looking for?
Wasn't it on the landlord, not the developer?
Or the landlord, whoever it is, yeah.
They had to pay the school taxes.
Yeah. Yeah. The person renting out the apartment had a covenant to actually pay for the extra children that go to the public schools. Actually, Celeste was next. You're perfect, right? Right? So the upshot of this is it was impossible to have any sort of home with children living in it. Right? And the fear was, well, if all these people are coming here, they're going to drain our public schools. The way New Jersey is unique, where you have funding for public schools not from the state, but from the local municipality. A lot of states do have a sort of similar regime. So this was meant to keep a low burden on the school boards. There's also opportunities for building adult retirement communities because elderly people don't usually have school-age kids, so that wasn't a drain on the economy. So the court goes through this long discourse on how everything is terrible in this community and it's impossible for poor people to live there. And they say, this can't go forward, right? We can't have this sort of zoning policy. Again, generally, you read a case like Euclid and they talk about apartments as being parasites, right? And then you read Justice Douglas who says filth and all this other stuff, right? But here, it's completely opposite. So, Madison, walk me through the court's actual legal analysis. What do they actually decide here?
So they said that the zoning regulations, they have to promote the general welfare, and it was clear that the provision would go against it. So basically they can't effectively prevent low and moderate income families
And how Madison, I almost said Marbury, I'm so sorry. That's a good Freudian slip. How Madison are they supposed to do that? Right? How are they supposed to accomplish that goal?
By not passing or what is it? They have to modify their zoning ordinances, and they have to amend their zoning ordinances and ensure that provides for opportunities for these low.
Yeah, very good. So this is a concept known as affirmative action. And most people hear affirmative action and think, oh, preference is education. The phrase actually had a very different origin. Most people don't even know the origin. In the 1960s, President Kennedy issued an executive order that said any federal contractor that does business with the federal government had an obligation. That to eradicate any sort of racial discrimination in their hiring. But they also had to take affirmative action, that is, positive steps to ensure people of all races are employed in their firm. Now, what those steps are, open question. So it's not enough here for them to perhaps eliminate racial covenants, like in Shelley v. Kramer, right? They have to take affirmative action, positive steps, to zone in such a way that people of different incomes can live together. Now, what is the basis of this ruling? Well, the state court's interpreting its own constitution. I'll leave it there. But you know about New Jersey. They like doing things that overturn the common law. That's what they do. But once you make this recognition, it's now an affirmative duty of the city. The court supervises how the zoning codes are drafted. Right? The court's going to supervise this. And the upshot of Mount Laurel is a long, long history. This went on for decades, where effectively the court put almost all of New Jersey under supervision. And at first I said, okay, we'll let you do this on your own. See how you guys do. And as you can probably imagine, they didn't do anything, right? They basically blew off the ruling because they said, who the hell are you to tell us what to do? And the court said, fine, we'll put you under supervision, where a judge monitored. And this is a huge area, just to give you a sense of the scale. Basically, this entire chunk of New Jersey was in this area. This is right outside of Philadelphia. And this went on for years and years and years. And eventually, nearly 20 years later, like in the 90s we're talking about, they finally were able to develop low-income housing, and they broke down the socioeconomic barriers in the city. Would that have happened independently of the courts? Probably. If you look at New Jersey, which is just right across, Pennsylvania, which is right across the river, they didn't have this sort of judicial order, and they actually were quicker in building low-income housing than was New Jersey. So it's a huge question about how effective the Mount Laurel regime was. But I think it does illustrate how some of the problems with race and exclusion do come to a head. In this case, the court actually did something about it. Okay, so any questions on Mount Laurel?
So you said this is a minority?
Oh boy, this is an outlier. It's not just a minority rule. No other court ever replicated this in any other jurisdiction I'm aware of. So this is basically a unique case. So don't ever cite Mount Laurel in a brief, but I do think it's a useful case to discuss how intersection of race and property law can be resolved by the courts. But don't take this as a rule of law. They should copy anywhere else. All right, anything else?
Is this a side note?
Yes.
You were right, it wasn't development.
Okay, that's fine. That's okay. No, what do I know? When you read a case 8 years in a row, sometimes you don't always remember the facts perfectly. All right, anything else? All right, that's all I have. This topic's light, so I'll see you guys on Monday.